Oyez, oyez, oyez. The Honorable Court of Appeals for the Fourth Court of Appeals, District of Texas is now open pursuant to call. You may be seated. Good morning. To my right is Justice Lori Massey-Brissett. To my left is Justice Todd McCray and Justice Lori Valenzuela. We're going to start off, first of all, the three of us, by thanking Judge Campbell and her staff. They have been more than gracious, and their hospitality has been exceptional, so thank you, Judge. I understand there's some students in the room. It looks to me, because I have some students of my own at home, it looks like you guys are on the right side. And I will just tell you very quickly, I know Judge Campbell has let you know that this is not your typical case. And I say that because many of us watch TV and we have some idea of what the courtroom looks like and what trials look like, and that is not the case this morning. Things are going to be a little different. We will not be accepting any type of evidence. The parties will not be hearing objections and sustaining or overruling objections, but instead we are going to hear argument from both sides. It'll be 20 minutes and a rebuttal argument, which is 10 minutes. There are three of us, not one of us, and most importantly, we will not make any decision today. So we will get started, and again, with those introductions, call this case. Court calls 424-00461CB. Erica Barrera et al. Versus Uvalde Consolidated ISD, Uvalde County, City of Uvalde, DPS, Texas Rangers. Can I get announcements from both sides, please?
John, Justin Williams here on behalf of the plaintiffs. I'm not sure what exactly on the appeal to call the plaintiffs, what I would refer them to. And I would tell you I'm hard of hearing. I've tried to put in hearing aids, but I'm getting so much feedback that I thought that they would be bothersome to the other attorneys, so I've taken them out. So if everybody can speak up if you're addressing me or anything that I need to address, I would appreciate it, just because I'm so hard of hearing.
We will do that. Thank you for letting us know, Mr. Williams. If there's any time that you can't hear us, just stop us and we'll be glad to accommodate, okay?
Thank you.
Were you able to hear me right now?
I'm ready to proceed, John.
Okay. Yeah, please ready.
Charles Ruggiero Jr. representing Uvalde County, Your Honor, the applicant.
Brianna Webb, representing the Texas Department of Public Safety.
And will the two of you be dividing your time?
Yes, we were dividing it 10 and 10.
10 and 10. Thank you. All right, Mr. Williams, you may proceed.
Thank you, Your Honor. May it please the court, I apologize that I'm using a walker, but I'm recuperating from a broken leg and waiting for a knee replacement that needs to be done after swelling goes down in my leg, and until I get that swelling down, I can't get the knee replacement. This is what I would say, a very simple case. It arises from the tragedy at Robb Elementary School on March the 24th of the year 2022. It involves the shooting of the deaths of 21 individuals, 19 students and 2 teachers, and it's a tragedy. I think nobody is going to disagree with that. The question is the responsibility, and I think there is enough fault and blame to go around. And after the shooting, there was investigations by both the Texas legislature and the Department of Justice. The then mayor Uvalde, who was Mr. McLaughlin, I think, who is now the representative, asked the Department of Justice to provide their analysis of what happened, and they did what is called a critical incident report. A lot of the things that we cited in our brief, and a lot of the things that were cited in the motions come from that critical incident report by the Department of Justice. The issue in this case for appeal is one that Texas Supreme Court has wrangled with for many years, and it's the Texas Tort Claims Act, and it is the use or non-use or defective property standards of the Texas Tort Claims Act. The Texas Tort Claims Act, as the Court of Appeals is well aware, was a compromise statute, and in the Robinson case, I think it is, the Supreme Court actually devotes a paragraph of that case to discussing the fact that the legislature has not given them any guidance as to the statute and its immunity limitations or non-limitations. I don't think that we really have much to deal with regard to that in this particular case. There are a couple of arguments that the defendants have made. They've made the argument that the actions of law enforcement were discretionary, the DPS, and therefore there's no liability for discretionary actions, but that is not the case here. In this case, what the critical incident report that the Department of Justice did, what it basically came to the conclusion was that the law enforcement on the scene failed miserably in their implementation of what is called active shooter protocol. Active shooter protocol is exactly what was set up for this situation. This is not a discretionary function of law enforcement. In this case, if you have A, then your response is B. If you have an active shooter, such as they had in this situation, then the response of law enforcement is supposed to be to implement active shooter protocol, and you take the shooter out. In fact, when the Border Patrol came, they had equipment that was not as defective as the equipment the other law enforcement. It was a different type of equipment, and it allowed them to implement that active shooter protocol. And within 10 minutes or so, they were able to take out the shooter and do their job as the law enforcement should have done before. So that one of the
So let's talk a little bit about that. You said defective equipment. And so I'll say tangible property. Tell me what the equipment, the defective equipment was in your mind.
I apologize, Your Honor, but I didn't hear anything you said.
Okay, so let's talk about the defective equipment.
May I?
Of course.
Your Honor, there was several items that were defective but we are going to focus today on the defective radios, which if you look at the videos of the shooting, you can see the fact that the radios were not, they were defective, they did not work inside the building. There has been an allegation by the manufacturer that they were never intended to work inside the building. Of course, we believe that is the most ridiculous argument that anybody's ever made. You're selling radios that are effectively not going to work 50% of the time when you're inside. That doesn't make any sense at all. Why would you even?
For just a moment. So are you alleging specifically that DPS and the county are responsible for the radios?
Excuse me. The radios in the active shooter protocol, which is what was the function that the law enforcement did not, it's the procedure they didn't implement. It calls for establishment of a incident commander or somebody who's in the lead and will make the tough calls. And in this case, because of the inability of the radios to communicate between all of the law enforcement that was there, they were spending so much time trying to talk to one another, they did not
But
ever.
Mr. Williams, were the radios used and controlled by DPS or the county? Or do you know who owned and operated the radios?
We know that the county did, but I don't know, I don't think that the statute requires that the specific entities that you are suing, that they actually have ownership of them, as long as it's a governmental entity. But
Right, there's case law that says that the governmental entity must be in control over using the tangible personal property that you're alleging was defective or misused. So that's why we're asking, are you alleging that the radios were being actively used by all of the defendants or just some of the defendants?
as far as we can tell, Your Honor, we have not, as you obviously can see, the last year of my life I haven't done a lot of discovery. So we're a little behind in the discovery process for being here. But I do think that both the DPS and the Uvalde County had the same radios that were, and I say that based on the videos, which seem to show multiple different law enforcement people having the same frustration to be able to communicate with each other. The people inside the building couldn't talk to the people outside the building and vice versa. And
What about the other equipment that was being used by the law enforcement officers? Are you alleging misuse or use?
no, we're not alleging that they misused them, but rather that the radios were defective for their intended use.
Right, I'm talking about the other equipment. There's, in your pleading, and you reference a testimony that said that the law enforcement had enough firepower, shields, and firearms to take the shooter down. Are you alleging that that equipment was not used or misused?
That it was not used, Your Honor. They did not ever implement the active shooter protocol, which would have required them to use the firearms. Firearms were never used until the Border Patrol arrived on the scene.
So how do you get around the Texas Supreme Court authority that says non-use is not used within the statute?
Well, we think in this particular situation, the actual use of the equipment is what is called for in the protocol. So if you're not going to use your firearms, your service revolvers or the rifles that you have on the scene, any of the equipment that you have with you, then there is no purpose for the active shooter protocol because it actually calls for them to use it. So I think this is an entirely distinguishable case because it does not involve a situation where law enforcement does not use, for instance, they don't use a battering ram, and it is a discretionary function as to whether they break down the door with a ram or whether they break it down with a baseball bat. I don't think that matters one way or the other. In our situation, it's totally different because if you're going to have the protocol work at all, you have to use your service revolvers, the equipment that you are provided as an officer. Without use of that equipment, then the active shooter protocol means nothing.
Mr.
So
Williams,
it's very distinguishable.
Mr. Williams, if you were permitted to amend, what facts would you add to establish jurisdiction over Uvalde County and over DPS?
If we were permitted to amend, I haven't really thought about the facts that I would add, but I'm sure Ms. Ramos would come up with the things that we hadn't thought of at the time that we drafted the original petition. And I think that was the proper response for the court to have provided at the time of this hearing, is that we should have been allowed to amend. If I think some of the facts that are some of the things that we just talked about, the fact that I would have gone into facts about why it is not non-use when the active shooter protocol is the proper response. It's the B to the A of the shooter. It is the proper response and it requires use of the service revolver. It is not a discretionary use of firepower, but it is the required use to take out the shooter. That's why it's so important to have an incident commander. Is you're going to have to, in the situation where you have an active shooter protocol, you're going to have somebody that's going to have to make tough decisions. I've actually communicated in my role as counsel, not in my role as the plaintiff's attorney, and told the law enforcement that it was my opinion that in an active shooter protocol situation, they needed to have somebody with combat experience or who has experience with being in a firefight where people are exchanging shots. because that is not something that a lot of people on who are I've been handed a note that says that the radios were used and the problem with them is they didn't work. And that the firearms were eventually used at the time that the shooter was taken out by the Border Patrol.
That was one of the questions that was asked, and I'm not sure we got an answer. Okay, I'll speak up. Mr. Williams, I'll speak up. So one of the questions that we asked and you answered was that they were responsible for operating the radios, defective radios or not. The question that I had, or maybe Justice Brissett had, was, do you believe that they were responsible for the condition of the radios? Were they responsible for the defective radios, the condition of them, the condition of the tangible property?
I think that the fact that they were all aware, it appears from the timeline at least, that if you go through the timeline, that law enforcement on the scene, essentially the first responders on the scene were all aware of the situation, so they knew what they were facing. And to get more directly to your response to your question, I think they would have known that radios that were able to be used inside a building were going to be necessary. So were they responsible for the actual condition of the radio when it got to them? I don't think so. I think that's the manufacturer's job, and the manufacturer has been sued in another lawsuit. We divided, as a matter of legal strategy, we divided these cases up, and this case involved governmental entities, and it did not involve the product entities. That is another lawsuit, and we filed, because of the differences between product liability law and tort claims law, we figured one would provide us with enough problems and the other would without having them combined. So I don't really have those together.
I just want to clarify, are you alleging that all defendant governmental entities were actively using the radios on that day or trying to use the radios on that day?
They were all trying to use the radios on that day.
What about the other equipment? In your petition, you specifically alleged the use of equipment at the perimeter where they were holding people back from accessing the school. Which entities are you alleging were actively using the equipment in that regard?
Well, Uvalde, the Uvalde school district, which I don't think was ever served, so they're not party to this appeal. I think they, through the state of Texas, were responsible for the security fence, and that was the first line of defense. My understanding is that security fence was built around
Were any other, I'm sorry, I'm asking you because you're running out of town, were any other entities involved in the use of equipment in that regard, other than the school district?
Well, the door locks.
I'm talking about the use of the equipment at the perimeter, holding people back from entering the school.
I'm not really sure what you're getting at, Your Honor, I'm sorry.
In your petition, you allege that the law enforcement used equipment at the perimeter outside the school to hold parents back, tackling them, tasing them. Which governmental entities are you alleging used the equipment in that regard?
Can you tell me what entity that you are asking?
I'm I'm asking you, which governmental entities are you contending use the equipment to hold people back from entering the school?
I am not as familiar with that particular, that is not a big part of our claim, Your Honor. That is probably the smallest part of our claim, if it is a part of the claim, and I'm just not very familiar with that. The focus that we had was on the things that directly affected the hostage situation and the length of it and the killing of the individuals and prevented law enforcement or the county from implementing the protocol that law enforcement was supposed to implement. I see that my time is up. If you will bear with me, I have one very brief comment that I wanted to make, and that is that we did file a motion for continuance of this hearing, and the reason for it is I'm under the care of, or have been until this last week, of 4 doctors, 3 of which were working to reduce the swelling in my leg in order for me to be able to get the operation that's needed to take out the hardware they put in when I broke my leg and do the knee replacement. And this hearing has the travel, all of the things that have gone on with regard to the hearing. It has set me back and will set me back, and I would just ask that the court be aware of things like that. I know that there are times that you are, as justices, as we all are in practice of law, you sometimes wonder what lawyers are thinking when they file certain things. But there are other times that lawyers file things because they're necessary. And in this situation, for me, I did it because I thought it was necessary, and my doctors thought it was necessary. So I certainly wish that we'd have been able to do this at a different time when I would have been more able to be responsive to your questions. And thank you for your attention. I will pass my time.
Thank you, Mr. Williams. You may proceed.
I'll wait until he is. I'll get it for you.
Thank you.
Sure.
Appreciate it.
May it please the court, counsel. My name is Charles Ruggiero, and I represent Uvalde County. And I'd like to make a point. My firm has represented Uvalde County throughout the litigation, multiple litigations of the Robb Elementary shooting. This case in particular is unique, since the other cases are taking place in federal court, whereas this particular case only is alleging tort claim allegations. I would like to make a point. You might look at looking at the style. I wondered where all these other entities are. The city of Uvalde was sued in plaintiff's complaint, but was never served. They were dismissed. Uvalde County Independent School District was served and actually had to plead the jurisdiction pending at the time of the hearing. Then they were dismissed by the plaintiffs. So the only 2 entities right now that are left are Uvalde County and DPS. I would assert of the court that under the, as far as our briefing, the 3 exceptions, all of which exclusively or inclusively would control as far as governmental immunity. Under 101.1021, the tangible property exception, there is no showing by the plaintiffs of the negligent use of tangible property belonging to Uvalde County that was the direct cause of this incident.
Mr. Progerio, I want to give the appellant's counsel a little grace and ask you the questions that I needed to get from him. Because I'll remind you that we have to liberally read the plaintiff's allegations, and I know you know that. Looking at the plaintiff's allegations, it does talk about the use or misuse of property in the sense of the radios and the equipment held by the officers in the hallway and in the perimeter. How do you construe that those pleadings in light of Texas Supreme Court law in terms of whether it is use or non-use that would apply in this case?
Well, one, the dispatch system was the city of Uvalde County. It was not, excuse me, the city of Uvalde, not Uvalde County.
But are we allowed to take your statement on that, or are we limited to what is in the pleading and liberally reading the allegations of the pleading?
I believe it's actually part of the briefing because they put the DOJ report has that in there. It shows that the dispatch system, I mean, everybody, each individual entity has radios, but the dispatch system where it comes through was the city of Uvalde, and still is the city of Uvalde. So I would say, and again, I would be under Bosley, I think the issue really is what is the cause of this horrendous murder? Salvador Ramos murdered 19 children and 2 teachers. His actions during the first 4 minutes that he entered the school caused this tragedy.
But aren't the damages in this case much broader than just the initial shooting? It's the failure to render emergency aid, it's the trauma that these people went through for over an hour. It's not just the shooting, is that correct?
Some of the other plaintiffs, especially these plaintiffs in this particular case, are, I would say, the collateral plaintiffs that happened to be children in the school that were not in 111. However,
So when you go to my question was, relating to the property that we've talked about, both the radios and the equipment held by the law enforcement in the school and at the perimeter and actively used at the perimeter. How is that not use or misuse of property with regard to the Texas Tort Claims Act?
well, the property was not misused, and you can say off the radios were defective, it still wasn't caused in Bosley. Just like in Bosley, the door that happened to be opened by the technician as the patient ran past him, it wasn't the door that was defective. The ultimate cause of his death was he ran in front of a truck and committed suicide.
Right, again, but we're not talking about just the deaths, we're talking about the survivors and what they endured for over an hour. And had the radios worked properly, wouldn't that hour have been traumatically cut?
Those survivors that we're talking about, again, discovery hasn't been really even commenced in this case, but the DOJ report is evidence of the fact that these children were taken out. So the 77 minutes that we're talking about are the children in room 111. And that's what we're talking about. The reason we're here was 77 minutes because we didn't have ballistic shields. Once the ballistic shields arrived from the U.S. Marshal Service in Del Rio, the breach of the door was obtained and the situation was neutralized. There were 2 individuals from Vortac, one from Uvalde County and a deputy sheriff, and a deputy sheriff from Zavala County. 4 went in there and neutralized the subject once the ballistic shields were in hand. Otherwise, we'd have a suicide situation. Even with these ballistic shields, the first Vortac member was shot in the head, but was fortunate to wear a helmet and was able to survive. But he was disabled immediately against the first one to enter. The other 3 entered and neutralized the subject. That's why it took 77 minutes, and that's why there was the tragedy that did occur. Before I run out of time, I'd like, of all these instances, I'd like to emphasize the method of providing police protection, which I think is conclusive in this area also. Naomi Robinson versus City of San Antonio, which was a case that I personally dealt with Phil Harberger, a colleague in the 4th Court, before Rose Spector eventually wound up in the Texas Supreme Court. That particular case was tragic and eerily so at the same as this case because Mr. Robinson kidnapped his child from his ex-wife and was held up in his apartment. The police arrived at the scene, they attempted to negotiate, they couldn't, it was unsuccessful. He killed his daughter, and killed himself. Plaintiff brought a cause of action claiming that you did not use the correct route. You did not use, the radios were incorrectly used because you shouldn't have tried to negotiate, you should have just breached, and this tragedy would not have happened. Ultimately, the court held that that was a method of providing police protection under the Tort Claims Act, and there's no waiver. And that is what I would assert in this case, Your Honor, that this was a method of providing police protection. We had to wait till the ballistic shields arrived.
You're talking about section 101.055, and section 2 is discretionary calls in the wake of an emergency call. And section 3 is the method of providing police protection. You're saying Robinson applied 101.055 section 3 instead of 2?
Robinson applied a 3 as a method of providing police protection.
Was Robinson reviewed by the Supreme Court?
Certainly not.
Okay. And so, are you aware of the case law around the country that shows that in this kind of a statute, where the more specific statute, where there is a more specific section, it should apply versus the general, and that the method of providing police protection subsection actually goes to the larger, higher level policy and funding decisions, whereas section 2 goes to the calls or the decisions made in the wake of an emergency call?
Well, I think Robinson is controlling. It was the Fourth Court of Appeals opinion, and there's never been a version.
Do you have that quote? Is it in your brief? I did not see that in your brief. Oh, wow, thank you.
I can get you the site out, but it is the reason. The other issue that we also, as Barrera versus City of San Antonio, 101.0552, the emergency situation, we also feel that is controlling as well. Either one of the three, we feel, shows that there is no waiver of sovereign governmental immunity made for Uvalde County as well as DPS. I'd like to also address the issue of the radios. City of Dallas versus Sanchez, a case we decided in our brief, where they alleged that the 911 system was defective, and the EMS did not come to the situation in time, and the individual died from drug overdose. They held that was not, the allegation of defective EMS equipment was not the cause. The cause of the fact that you overdosed on drugs, and that was the cause of
What's the name of that case?
City of Dallas versus Sanchez. It's also. Also, with regard to, there are plaintiff's allegations concerning negligent training, discipline, and the use of the active shooter protocol. One, I would say that the active shooter protocol is not a law or ordinance that we're speaking of under the Texas Tort Claims Act. It is an active shooter protocol that people in all government agencies are starting to train their officers with. And in 2022, it was not well known, and it was not being used. But the fact that that was not being used does not create liability. It does not waive government immunity for Uvalde County. That's the case of Texas Department of Criminal Justice versus Campos, which was cited in our brief also, which is the Supreme Court.
I have one question, and I know you are out of time. In your brief, you argue that the dispatch system is operated by the city.
Correct.
And versus the county. Was that raised below, or is the first time we're seeing it in your brief at the appellate court?
No, it was raised before.
It was raised below?
Yes.
Okay. Thank you, sir.
Thank you, Your Honor.
May it please the court? Counsel, my name is Brianna Webb, and I represent the Texas Department of Public Safety in this case. The plaintiffs alleged three things against DPS specifically. One, that the failure to follow active shooter protocol. Two, the failure to check to see whether the door was locked. And three, that use of faulty radio devices and equipment approximately caused the injury in this case. But this court should affirm the lower court's finding that DPS is entitled to sovereign immunity because the plaintiffs failed to plead a waiver under the Texas Tort Claims Act. And even if they do plead a waiver under 101.021, further exceptions apply under 101.055 and 101.062. Going to 101.021, a failure to follow an active shooter protocol or failure to check a locked door is a failure to act and not a waiver under the Texas Tort Claims Act. From what Lincoln was arguing earlier, it seems that he's saying that the use of the radios was part of the active shooter protocol, and the use of the equipment was part of the active shooter protocol. And because they didn't use that equipment, it was negligent implementation of the active shooter protocol.
Actually, I think what they're alleging is that because they could not communicate, they could not implement the active shooter protocol.
Okay, and I think that, and that's right. I think that the way that I heard him say it was that they did not do the active shooter protocol because they failed to use the equipment. The failure to use equipment is not enough under the Texas Tort Claims Act.
No, that's not what I'm hearing the allegation. The allegation is that because the radios did not work in the building, they were unable to communicate and implement the active shooter protocol. He's alleging that by using radios that were unfit for the purpose and the incident, that caused them to not be able to do their job.
Right, so ultimately, he's saying they did not implement the active shooter protocol because of the equipment. And
But they're not saying they failed to use it, they're saying they couldn't use it. They had to leave the building, be away from the building to actually use the radio. So those are two different things.
okay, so if we look at that, the DPS failed to use the equipment and therefore could not implement the active shooter protocol, then that doesn't fall under the Texas Tort Claims Act because negligent implementation or no implementation of a protocol does not fall under the Texas Tort Claims Act waiver.
Why not?
Under Maspero, City of San Antonio v. Maspero, the Texas Supreme Court found that there is no independent waiver for a negligent implementation of policy.
But this wasn't a negligent, this is not, I don't think they're alleging negligent implementation. They're arguing that there's no question that the protocol should have been implemented. That's not a discretionary call, given the situation. And therefore, if the use of the radios caused them not to be able to implement the active shooter protocol, then the use of the property caused them to delay in their reaction.
And that delay is the possible cause.
Okay, so if the plaintiffs are alleging that the use of the radios delayed the ability to render aid to the plaintiffs, and that's the proximate cause of the injury, that is also not a waiver under the Texas Tort Claims Act because they haven't alleged enough facts to show that the use of the radios was actually the proximate cause of the injuries.
But if they allege that it was, do they have to prove their case in their pleading?
Well, I think they have to at least allege that it was the proximate cause, and not just by, saying, well, it is the proximate cause, but what they're saying here is that the DPS used the radios, but that the radios were dysfunctioning and they didn't have any way to show that the proximate cause from the use of the radios to the mental anguish of the plaintiffs.
So you would agree that they don't even have to prove their case in their pleading. We have to liberally read the pleading to determine whether allegations are of the type that allege that the use of property was a cause of the damages incurred by the plaintiffs. And so if they have alleged, if we liberally read the pleadings and we believe that the pleading alleges that the use of radios that did not work in the building caused the delay in addressing the shooter and the victims, why is that not used under 021?
It is used. What I'm saying is that the Texas Tort Claims Act also requires that it be the proximate cause of the injury.
And if they allege that it was the proximate cause, what would they have to do?
Our argument is that they haven't alleged that it was the proximate cause, because under the city of Dallas v. Sanchez, the proximate cause must serve as a substantial factor in causing the injury, without which the injury would not have occurred.
Right, and they're alleging that the failures of the radio caused them to not implement the active shooter protocol, which caused the delay and why it took 77 minutes to get in there. They're not saying it caused the shooting. They're causing it caused the delay, and therefore the damage is covered by these plaintiffs, not the ones that died.
Right, yeah, but there's no allegations as to how the radio, the use of the radio actually caused the mental anguish of the plaintiffs in this case. And how without the use of the radios, the mental anguish would still have occurred. If there was no shooter, if there was no other intervening causes, such as strategic decisions, use of other equipment or not use of other equipment, there would not be any mental anguish.
Are you saying the mental anguish is not greater by sitting there for 77 minutes versus 10?
I'm not saying that it's not greater, but I'm saying that the law says that the injury would not have occurred. And so the mental anguish would have had to not occur at all.
What law are you relying upon for that?
City of Dallas v. Sanchez.
And that says you have to show that it can't be, in any personal injury case, if something exacerbates the injuries, there is a cause for that damage, correct?
Right. And what I'm arguing is that an exacerbation of the injury is not enough.
And you're alleging Sanchez tells us that exacerbation of the injury is not enough.
That's correct. And Sanchez also tells us that that this exacerbation of the injury, for example, the Sanchez case is the one where they had the phone disconnected and the 911 phone system went down. And there's a long delay in the emergency response to the decedent in the case, who ultimately died of an overdose. The Texas Supreme Court found that it was too attenuated, that the malfunction in the radio or the 911 dispatch system was too attenuated of a link to connect to the overdose, even though it made the injury worse, or it could have prolonged the ability for the ambulance to get there or to render aid, that it was not enough because it must serve as a substantial factor in causing the injury, and without which the injury would not have occurred at all.
Do you think that Sanchez is distinguishable, and that in that case we're talking about the death? And in this case, we're not talking about the deaths, we're talking about the people that survived. So any delay for the survivors, any minute that they had to listen to what was going on around them, any sounds of shooting, is there not a proximate cause between the delay that they sat and listened to that? And is that distinguishable from Sanchez, where we have a death resulting from the overdose?
I understand your question, and I think that even though Sanchez dealt with a death, that there's that the law still applies, that there's going to have to be a proximate cause without which the injury would not have occurred at all. And in this case, even though there was a delay, the delay is not what caused the injury. Even the mental anguish. What caused the mental anguish was the other circumstances going on in the case and going on surrounding. The use of the radios itself was not what caused the delay or what caused the mental anguish substantially under City of Dallas v. Sanchez.
And you're saying specifically that we're going to find the word substantially in that case?
Yes, the vote is must serve as a substantial factor in causing the injury, and without which the injury would not have occurred. And as my time is running low, I wanted real quick to address another exception that has come up and recently been addressed by the Texas Supreme Court after the briefing in this case. There is a new case that came out, City of Killeen and Killeen Police Department v. Terry, 712 Southwest 3rd, 101. This is a Texas Supreme Court case that came out on April 25th of 2025. And this was the first case that has ever actually distinguished the emergency exception of 101.055 and another emergency exception of 101.062. 101.062 has the same standard as 101.055 about whether the employee is responding to an emergency call, and that is an exemption from the Texas Tort Claims Act waiver if the employee is responding to an emergency call and in compliance with the laws and ordinances applicable to the emergency action, but it does not have a conscious indifference for reckless disregard standard, like 101.055 has.
Thank you, Ms. Swin. And I just want to make sure that I'm correct on that. It was 712 Southwest 3rd 101, correct? The clean case?
Yes.
Thank you.
I apologize, I'm having trouble between the podium and my walker. I can't seem to get close enough to the microphone to even hear myself, much less hear the honorable justices. But I want to talk about two different cases that were cited by the defendants. The Sanchez case, which involved a 911 call, was held that there was no proximate cause because the 911 call, the first thing is that 6 hours passed between the call and the death of the young man. The second thing is that there is no way that the court could tie together the malfunctioning 911 call and a drug overdose death. There was no proximate cause between the two. That's not the case in our situation. We have, first of all, let me address the second point that the county raised, that it's said that this is a discretionary function. Active shooter protocol is not discretionary. In police work, if you have certain situations, you have certain responses that are written down that you're supposed to respond to. In this situation, they had all of the elements of an active shooter, so that active shooter protocol is, in my example, if you have A, you do B. If you have an active shooter like they had here, then the active shooter protocol is the proper response. All of the things that they were doing that were discretionary were things that delayed the response and probably extended the pain and suffering of the different plaintiffs. One of the things that is also very different about this case is the actual actions of the Sheriff's Department and the DPS directly led to the delays, and the delays themselves are the damages the plaintiffs are seeking recovery for. The Border Patrol arrived and their radios worked and they were able to implement active shooter protocol. All evidence that if the radios had worked, active shooter protocol could have been implemented and this person taken out in less than 10 minutes, which is what the Border Patrol did. And I don't think anybody in this courthouse would have the audacity to say that less than 10 minutes of hostage situation is the same as 77 minutes or over an hour. You know, over an hour that these children were put to watching and listening to the screams of their classmates as they were killed by the shooter is much different than 10 minutes. And I think that directly affects the case. Robinson, the case that they cite for the discretionary standard, Robinson involved a protective order that the court held was not actually property. So the police discretion was not really the main issue in that case. It was the misuse of the protective order, which the court held not to be property. As I think all courts would probably say that your orders are not the same as a radio. You know, no person in this courthouse, I don't think, including the Uvalde County, would disagree with the concept that the radios were property and fit the tangible personal property exception of the Texas Tort Claims Act. What we're dealing with here and what is the difficulty is we are dealing with a legislative created immunity where there was originally under the sovereign immunity doctrine, you couldn't sue the king because the king was the king and he didn't like to get sued, and so you couldn't sue him. But the legislature, as time passed on, and we learned a lot more about how things function and how governments work, then the legislature is creating exceptions to that. And in doing so, while I am sympathetic with the Supreme Court and the fact that the legislature they didn't really define the things that they kind of cut out from the exceptions. I do think that the legislature had a difficult decision in how do they create law that both sides of the issue, those that think the government shouldn't be sued and those that don't think the government's any different than any other entity, how can you make both of those different sides happy? And I think they probably didn't, but I don't think they could. I think that was the difficulty in this act, and that's the reason we're here today, is because it's a difficult situation to come up with. I think that Sanchez is not.
Mr. Williams, let me ask you, would a private person be liable for these claims under the Texas Tort Claims Act?
If this was a private entity, I don't think there would be any question. We wouldn't be here today arguing over the things we're arguing over if there was a private entity, because you could sue them for their negligence in bringing radios that the allegation would be they knew the radios wouldn't work in a school building and they knew they were going to a school building. Guess what? Schools teach children in buildings, and the radios didn't work in the building, so that wasn't a surprise, or should have been a surprise to law enforcement. And they knew their radios. If you look at the critical incident report, Uvalde School District's chief of police, Pete Arugement, who I think was fired after this incident, he discarded his radios when he arrived on the scene. And one of the reasons he discarded them was they didn't work inside the building, and he knew that. So I don't think there's any question that law enforcement knew the radios didn't work inside the building. They quickly learned it to their frustration from looking at the video. You can see that they're all frustrated by the fact that they are not able to communicate with each other. The Sanchez case, if I can be so bold as to, although disconnection of the telephone call may have contributed to circumstances that delayed potentially life-saving assistance, the malfunction was too attenuated from the cause of Sanchez's death, a drug overdose, to be a proximate cause. So in that case, clearly they held that the allegation of the problem with the government property, the malfunction of the 911 system, was not a proximate cause. Here, the radio's malfunctioning led directly to the failure to implement the active shooter protocol. And the failure is exactly what led to the hostage situation being extended for over 77 minutes. And that caused all of the plaintiffs, or a majority of the plaintiffs' damages. If it had been less than 10 minutes, we probably wouldn't be here today. And the Border Patrol, the fact that they were able to arrive and implement active shooter protocol very quickly with radios that work is evidence that working radios would likely have allowed the active shooter protocol to be used, which it should have been. And that is, I think that evidence is very clear to the court, because if that law enforcement agency is able to use their radios that work and then to implement the shooter protocol to take out the shooter in less than 10 minutes, why were the people who couldn't talk to each other waiting for battering rams and snipers and all kinds of different things that didn't arrive, and it only delayed the hostage situation, which is directly, since it's directly involved in the claim that we are making, is obviously a proximate cause. Thank you, Your Honors. Appreciate your listening and your attention.
At this time, court is recessed. This case will be submitted.
Thank you.
I think probably one of the more difficult things for me over the course of that is
Like to say, like questions to the justices say, especially if you all have questions about. Please don't ask them any questions.